For this Fox News alert now on something that is taking shape in the last hour, a New York federal judge has ruled that the huge metadata grab by the NSA was lawful. And this is a big case because the ACLU was going after James Clapper, the director of national intelligence, over this. And what this New York judge is saying is that, no, you can grab all those, albeit there were tons of them and probably, more than they needed to get, but it was lawful. Fred, your reaction to this?
I think he's dead wrong. I agree with the judge of the District of D.C. last week. I think this is a flagrant violation of our Fourth Amendment rights to just grab data from everyone. And you have to understand something. This is what's called packetized data. So when you make a phone call or you have an email, the data is in a little box. At the top of the box is called a header, and in that header is information about where the call was made and stuff like that. The NSA grabs the entire box. It's all sitting in one of their servers out in Utah, and they can look in and see what the conversations are about or what the emails are about with the flick of a switch. And I think that's incredibly intrusive. And without probable cause or some suspicion as to why they should go through my emails, your cell phones, Ebony's cell phone, I think it's just wrong.
Ebony, does this open the door for other states to take a look at this too? I mean, what happens after this point?
Absolutely, Harris. It opens the floodgates here. And again, this is not narrowly tailored enough. We do have Fourth Amendment protections against unreasonable searches and seizures. And I agree, this is absolutely flagrantly unreasonable. It's beyond the pale. Now, again, if you can give some articulable suspicion to something specific that you're looking for, totally understood, fair play. There is a safety concern here. But without that, in the absence of that, Harris, it's overbroad and it's absolutely unconstitutional.
Here's what the judge said. No doubt the bulky telephone metadata collection program vacuums up information about virtually every telephone call to, from, or within the United States. He still says it's lawful. Fred?
No, I mean, think about it, Harris. Could you imagine if the police went into everyone's home at night and rifled through their papers and said, look, we're just going to photocopy these in case in the future we decide to look into you for terrorism? Everybody would agree that that's a violation of the Fourth Amendment. You just can't grab this stuff up. Ebony's right. You have to have some reasonable, articulable suspicion to look at specific people's cell phone data and usage. That's not a violation. This is. And look, we now have two decisions, one from the D.C. Circuit, one from the Second Circuit. Ultimately, the Supreme Court's going to have to weigh in on this. But, you're watching your Fourth Amendment rights get eroded away.
Very
Pay attention.
Interesting. And some lawmakers, Representative King here in New York, has issued a statement saying that this is what's needed to keep us safe. Twitter is alive on this. How much more will American people take? Privacy and liberty gone. From Roadhog Rider on my Twitter page right now. Good to see you both. Thank you for handling this.
Thank you, Harris.
Sure.
And finally today, the NSA strikes back. Today, a federal judge in New York ruled that the NSA's bulk phone records collection program does not violate the law, and that it serves as an effective, quote, counterpunch to al-Qaeda. Those were the words of U.S. District Judge William Pauley as he dismissed a lawsuit brought by the ACLU back in June following the Edward Snowden disclosure that millions of Verizon customers in the United States were having their phone data collected and stored by the government. The ACLU argued such collection violated an individual's Fourth Amendment right to privacy and First Amendment right to free association. But in the 54-page decision, Judge Pauley argued the NSA's bulk collection program is not being used in a way that violated the constitutional rights of average, law-abiding Americans. He notes there is no evidence that the government has used any of the bulk telephony metadata it collected for any purpose other than investigating and disrupting terrorist attacks. Now, this ruling comes less than 2 weeks after a federal judge in Washington, D.C. came to a different conclusion about the NSA's bulk phone records collection program. Judge Richard Leon ruled the program to be likely unconstitutional, arguing, I cannot imagine a more indiscriminate and arbitrary invasion than the systematic and high-tech collection and retention of personal data on virtually every single citizen for purposes of querying it and analyzing it without judicial approval. With this latest ruling, it's looking more and more likely that the Supreme Court will be the final arbiter when it comes to the NSA's spying programs, although that will likely take a few years.
Last week, a Washington, D.C. judge ruled that the NSA's collection of phone metadata was likely unconstitutional. Well, today that same program was back in court. Correspondent Doug McKelway has today's reverse ruling.
The ruling by U.S. District Court Judge William Pauley found the NSA's collection of metadata from every phone call made in the U.S., to the U.S., and from the U.S. is constitutional. He reasoned that after the September 11th attacks, the U.S. found al-Qaeda used technology and decentralization, and that, quote, the cost of missing such a thread can be horrific, and that the metadata collection program represents the government's counterpunch. Supporters of the program, first leaked by Edward Snowden to the Guardian newspaper, hailed the decision.
This decision puts it in perspective. There are no constitutional violations. The NSA goes to extraordinary lengths to make sure that everything it does is entirely constitutional.
The Justice Department's terse response, quote, we're pleased with the court's decision. The ACLU said it will appeal because the ruling, quote, misinterprets the relevant statutes, understates the privacy implications of the government's surveillance, and misapplies a narrow and outdated precedent to read away core constitutional protections. The decision is contrary to another district court ruling this month that found the NSA program unconstitutional. District Court Judge Richard Leon wrote in that December 16th ruling, quote, I cannot imagine a more indiscriminate and arbitrary invasion than the systematic and high-tech collection and retention of personal data on virtually every single citizen. The jubilant plaintiff in that case called it a victory for the Fourth Amendment protections against unlawful search and seizure.
Any judge who was following the law would have made this decision.
Friday, an angry claimant leveled a caustic accusation against Judge Pauley.
Judge Pauley did not follow the law. The law is clear that American citizens can come into district court, a court separate from the Foreign Intelligence Surveillance Court, to challenge what the government is doing in terms of spying on them. This judge ignored that.
These two contrary rulings almost certainly guarantee that the Supreme Court will have to decide the constitutionality of the NSA surveillance program. Shannon?